Welcome back to Breaking History, the Supreme Court Historical Society's show, where we highlight modern scholarship about the U.S. Supreme Court's endlessly interesting past. I'm Ross Davies, and today I am joined by Helen Knowles-Gardner, who is managing editor of the Society's Journal of Supreme Court History and also research director at the Institute for Free Speech. We are here to talk with Helen about her latest article in the Journal of Supreme Court History. The title of her article is long and intriguing. Quote, "The court is disposed to consider the merits. Wow!" End quote. Anthony Lewis takes us inside the oral arguments in NAACP versus Alabama ex rel. Flowers, 1964. Behind that title is an even longer, complicated story of civil rights litigation in the Alabama state courts and the U.S. Supreme Court from the mid-1950s to the mid-1960s, along with the story of Anthony Lewis and his coverage of that litigation in the Supreme Court. So, in the 20 minutes or so we have together today, we must make choices about where to focus in all that long, complicated history. We will start with a sketch of the significance of the Flowers case and how it fits into the Supreme Court's freedom of association jurisprudence as it developed in the 1950s and 1960s. And then, once we have that in place, we will turn to Helen's fascinating observations about Anthony Lewis and his fascinating observations about what went on during the oral arguments in Flowers. So, Helen, please tell us about the Flowers case and freedom of association.
Well, thank you, Ross, and thank you for this opportunity to talk about this article, which was a real pleasure to write. It's part of a broader project where I'm looking at the history of Alabama's efforts to basically oust the NAACP from the state, efforts that were successful for 8 years. For 8 years from June 1st, 1956 until sort of late September 1964, basically the NAACP had no legal presence in Alabama whatsoever. All the work they were doing, all the work that we associate with them with regards to civil rights and voting rights simply did not happen in Alabama for those 8 years. Everything ground to a halt literally overnight on June 1st, 1956. Now, we are used to litigation taking a long time to percolate through the courts, but what makes this case particularly unusual is that it took 4 decisions from the nation's highest court before Alabama actually relented and allowed the NAACP back into the state. And so NAACP versus Alabama ex rel. Flowers, I'll just refer to it as the Flowers case. This was the 4th and final time that the case had come before the justices. And what you see in the justices' papers and in the oral argument and in the opinions in the cases, and particularly in the oral argument, which is where Anthony Lewis's papers become so useful, the notes that he took become so useful, is you see the utter frustration of the justices with Alabama just constantly thumbing their nose at the justices and just basically saying, we're not going to comply with your decision. And so the case starts. Formally, the case starts on June 1st, 1956, but in reality, it starts sometime in the summer of 1955, when post-Brown versus the Board of Education, Alabama is trying to find any way it can to basically to delay the inevitable. They can see school desegregation is going to come eventually, but they want to put every roadblock in place to prevent the inevitability of that, to delay the inevitability. And so sometime in the middle of 1955, some some white supremacist politicians, and I'm using that label because that's how they proudly described themselves, that they were white supremacists. They basically hatched a plan and went to the Alabama Attorney General, John Patterson, and said to him, we know a really good way to slow the momentum. It's basically to put the NAACP out of business. So over the next 6 to 8 months, this plan is hatched. And overnight, basically on June 1st, 1956, Attorney General Patterson goes to an incredibly sympathetic state judge in Montgomery. He goes to Walter B. Jones, who actually ends up being very important in Supreme Court history because he was also the first state court judge in Alabama to preside over New York Times versus Sullivan, decided in 1964. So Patterson goes to Jones and says, we want an injunction, put in place a temporary injunction saying that the NAACP has failed to register as a foreign corporation, as the NAACP was incorporated in New York State, and so consistent with pretty much the laws of all the states at the time, Alabama had a foreign corporation registration law that said if you were incorporated outside of Alabama, you had to register as a foreign corporation. In good faith, the NAACP didn't think it ever had to register under the terms of that law. And it had been operating in Alabama since, I think, 1918. And gosh darn it, Alabama had never enforced this law, never pursued this law. But post-Brown, all of a sudden, Alabama says, you know what? There's a way to put the NAACP out of business and to say, you are not in compliance with this foreign registration law. And so temporary injunction is granted. And about a month later, Alabama ups the ante. They say, okay, as part of complying with the law, we also want you to disclose various documents, including lists of every single member of the NAACP in Alabama. It does not take very much imagination to realize what would have happened if Alabama had gotten its hands on the lists of all of the members of the NAACP in the state. You don't even need to imagine what. You don't even need to think in specifics. Everybody knows what would have happened. So the NAACP said, absolutely no way. And Alabama just dug its heels in and said, no, you must provide these documents unless you don't ever want to come back to the state. If you want to come back and do business in the state, we must know who your members are. Fast forward to the spring of 1957, NAACP predictably have got nowhere with the Alabama state courts. Every single time the door is slammed in their face, that every single Alabama judge that the case comes before toes the Alabama party line. Got to disclose this material or you're not going to be able to undertake business in the state. And so in the spring of 1957, the NAACP files a cert petition with the court saying that the disclosure of this information is a violation of the First Amendment. There is an associational freedom that's attached to the freedom of assembly clause in the First Amendment. This is what the NAACP argues. On June 30th of 1958, the first time the Supreme Court hears this case, Justice Harlan writes an opinion for the unanimous court saying, yes, there is a constitutional right to associational freedom and that the NAACP cannot be compelled by the state of Alabama to disclose its membership lists. Alabama basically said, so what? And the Alabama courts kept on going. They kept throwing every procedural roadblock you can conceivably imagine at the NAACP for the next 6-7 years. 2 more Supreme Court decisions, 2 more unanimous Supreme Court decisions in favor of the NAACP in the meantime meant nothing to Alabama. And so finally, by 1964, when there's another Attorney General, Richmond Flowers, that's why it's now NAACP versus Flowers by 1964, the case comes up to the court for the 4th time, and that's basically where my article picks up, talking about the notes that New York Times correspondent Anthony Lewis took during those oral arguments. And really the value of those notes is focused on the procedural complexity of this litigation. I have to confess, I'm not a lawyer by training. And when I started to read the transcript of the oral argument and read the transcripts of the Alabama courts to this stage, I was being tied up in procedural knots because I had no idea where the court was going. And then I read Anthony Lewis's notes, and it was like he unlocked everything. It was the key to understanding this case in layman's terms.
So tell us a little bit about Lewis and sort of his role in the Supreme Court courtroom. For many of our viewers, listeners, he may be an unfamiliar character. Can you just say a little bit about his place in Supreme Court history?
He is, arguably I would say the most famous journalist ever to cover the US Supreme Court. Maybe people might take issue with that, but I would say he was the most famous journalist ever to cover the Supreme Court. And everything you read about Tony Lewis says exactly the same thing. He was able to put the court's work into layman's language. The average person on the street could pick up a Tony Lewis article and they would know immediately what the court had done in this particular case. He could distill those incredibly complex cases down into incredibly understandable language. He won awards, rightly so, for his work as a Supreme Court journalist. And although there aren't that many years of oral argument notes in his papers at the Library of Congress, what is there is just a gold mine for anybody who's writing about one of those cases where he happened to sit in and take these handwritten notes.
And you, in your article, sort of tastefully, strategically intersperse a few quotes from these notebooks. And looking at page 228 of the issue of the Journal of Supreme Court History, you describe Lewis being in the courtroom for oral argument in Flowers. And he's summarizing the NAACP argument. And you quote in its entirety, and this I think this is the kind of thing you're talking about. Continuing to summarize in note form, Carter, this is Robert Carter, the NAACP lawyer. 1, the procedural defect is non-existent. As I understand your article, if I understand this correctly, basically after that first loss on associational freedom, everything the Alabama courts do to slow things down is put up procedural roadblocks. They're not about substantive law and constitutional law. They're about, oh, you dotted your I's and crossed your T's wrong, therefore you're out, right? So 1, the procedural defect is non-existent. A, Alabama Supreme Court regularly ignores similar defects in briefs. B, in any case, the alleged rule is a triviality. In other words, Anthony Lewis has told us in a total of what, about 25 words, that the NAACP didn't make any mistake in the first place. Even if they did make a mistake, it's the kind of mistake the Alabama courts regularly, ignore. And even if it's not one that they would ignore in this case, it's a trivial thing. And that's the whole story of Flowers, right?
Right, and everybody knew. And Anthony Lewis you can see this if you read between the lines of his notes, everybody knew why Alabama in this one particular case was pulling the NAACP apart for these procedural irregularities that it just ignored in every other case.
And so what does Lewis do with these notes? Because he's writing for the New York Times.
Right.
What does he do with Flowers in the Times?
He uses some of these notes in his articles to basically bring the case to life for the readers, but he doesn't make a whole lot of use of these notes, which is what I found really intriguing. When I found these notes, I'd read all his articles, because anybody who wants to understand this stuff simply reads Anthony Lewis's newspaper articles to begin with. But then I uncovered his notes and I was like, wow, there's a lot of material here that just really explains how utterly frustrated the justices were that this case was coming to the court for the fourth time. And yeah, he just, when he writes these notes and he who's really an integral part of the history of the Warren Court, when Anthony Lewis exclaims, wow, at something that Chief Justice Warren has said during oral arguments, that's when you know that he's kind of a real witness to history here.
And correct me if I'm wrong, but one of the other things you get out of these notes is that Lewis identifies in his notes who is saying what in the courtroom. Is that
yes,
right?
I think that's one of the real values of these notes. I mean, we have tremendous resources at our disposal as Supreme Court historians these days with regards to oral arguments. We have decades worth of recordings and transcripts through the oea.org website. That's a wonderful resource, but particularly for the older recordings, such as the one from 1964, there will oftentimes be gaps in the transcript because whomever is transcribing the oral argument simply doesn't know who was asking a question or which justice was responding to something that one of the lawyers said. Now, you and I have been doing this a long time. We can also recognize a lot of those voices, but sometimes the audio quality is really bad and you just simply don't know. Every single time Anthony Lewis writes something that the justices said, he writes the initials. And hey presto, we know who asked these questions.
That's wonderful. Now, I have to ask, because all litigation, right, even Jarndyce v. Jarndyce, eventually comes to an end. How does the story of NAACP versus Alabama XREL, whoever, including Flowers, how does it end, Alan?
One would think that after 4 decisions of the nation's highest court, that Alabama would just give in. It takes a couple of months. It takes a couple of months of the state courts coming to the reality that this is over. I honestly have to say that it helps that Judge Jones has at this point in time passed away. Because if he had still been alive in June of 1964, I think he would have just kept on pushing this case along and would have said to the court, no, I'm sorry, we're just going to make you continue to litigate this. At the end of Harlan's opinion in Flowers, he says, and I quote, should we unhappily be mistaken in our belief that the Supreme Court of Alabama will promptly implement this disposition, leave is given the association to apply to this court for further appropriate relief. That's Harlan basically saying 4 is enough. And that if Alabama doesn't comply, come back and we will find a different way to make them comply. Well, the Alabama courts continue to resist for a couple of months. And one of the state courts writes an opinion that the NAACP's deputy executive director accurately describes in a wonderful letter as a snotty opinion. It's Alabama saying, oh, I'm sorry, the US Supreme Court? No. We're the highest court in the state. We supersede the nation's highest court. But by the time September, October rolls around in 1964, Alabama courts finally give up. And on Halloween 1964, that's when the NAACP started to have reorganization meetings in Alabama.
Wow, that's quite a story. Before we go, can we return to Anthony Lewis for one more question, which is these papers. Where are they? What's in there? Are you done with them, or is there more to come?
I'm probably done with them because I'm sort of laser focused at the moment on the NAACP versus Alabama litigation, and there are no more notes from that litigation. But as I mentioned earlier, this is a goldmine resource for students of Supreme Court history, and I would encourage anybody who has any interest in Supreme Court history, first of all, to go and look at some of the newspaper articles that he wrote, because his understanding of the court is just journalistically is par none. That nobody can touch what Tony Lewis can tell us in those articles. And then go and have a look at his papers for yourself as a researcher. His papers are in the manuscript division of the Library of Congress in Washington, D.C. They're very accessible, and the wonderful librarians there, they told me about these papers, and so a huge shout out to them, the staff there. They were the ones that basically made this article happen.
That's wonderful. Thank you very much, Helen. There is obviously a lot more that Helen could tell us about the Flowers case, about Anthony Lewis, and about freedom of association in the Supreme Court. You can get started on all that by reading Helen's article in the latest issue of the Journal of Supreme Court History, volume 49, number 3. And you can subscribe to the journal by becoming a member of the Supreme Court Historical Society at www.supremecourthistory.org. Thank you very much for joining us for this edition of Breaking History. We will be back soon with another new and interesting look at the past.